Definition of frame or receiver and identification of firearms. So what are the reasons for the change? The Justice Department was tasked to amend the federal regulations to accomplish several key issues. First and foremost, to remove and replace regulatory definitions of firearm, frame, or receiver because current regulations fail to capture the full meaning of those terms. Also, to clarify the meaning of the term firearm and gunsmith, and also to provide definitions for certain terms such as complete weapon, complete muffler or silencer device, multi-piece frame or receiver, privately made firearms, and readily for purposes of clarity due to advancements in firearms technology. The department also amended ATF's regulations on marking and record keeping that it deemed necessary to implement these definitions. The final rule will become effective on August 24th of 2022. After the notice of proposed rulemaking process was completed, which involved a comment period from industry members and the public, the final rule was signed by the Attorney General on April 11th of 2022. From there, it was published in the Federal Register on April 26th, which started the 120-day countdown that will take us to the August 24th effective date. Goals of this rulemaking are to address and balance many issues, as you can see in this graph. Briefly going through the visual, you can see how many important topics overlap. Changes in technology and terminology, unserialized guns made by private individuals, often referred to as ghost guns by the media, minimize disruption and cost to the industry, allow for more successful traces and inspections, provide sufficient legal authority, and adverse court cases. Topics of discussion will be broken down into 6 sections. Definition of firearm, frame, or receiver, privately made firearms, often referred as PMFs, marking requirements, record-keeping requirements, record retention, and ATF rulings and procedures affected. You'll find that all of the above topics are interrelated in the fact that changes in one area will require changes to another. We'll start with the topic of definitions of firearm, frame, and receiver.
Defining frame or receiver. Background. The Federal Firearms Act, which preceded the GCA, regulated any part or parts of a firearm. During congressional debates in the 1960s, Congress recognized that this was cumbersome, and in passing the GCA, Congress determined that it would regulate only the frame or receiver of a weapon. However, Congress did not define this term in the statute. In December of 1968, the Department of the Treasury defined that term in the GCA implementing regulations as that part of a firearm which provides housing for the hammer, bolt or breech block, and firing mechanism. However, relying on the hammer, bolt or breech block, and firing mechanism raised some issues. For example, some firearms, including handguns that utilize strikers, do not have hammers. Second, many firearm designs do not have all 3 of these components in the same part of the firearm. Finally, although this definition provided guidance as to which part was a regulated component, it did not provide analysis as to when that part is regulated, at what stage it becomes a regulated part. It is important to understand that, pursuant to the requirements of the Administrative Procedures Act, agencies may publish regulations to implement statutes within their delegated authorities. In such regulations, agencies may define terms left undefined in the statute or prescribe rules that are necessary to carry out the provisions of the statute. Such definitions or rules may also be amended pursuant to the procedures prescribed in the Administrative Procedures Act. These amendments may be promulgated even without a change to the underlying statute. So, for example, ATF may define and amend the terms frame or receiver or gunsmith, or it may amend regulatory requirements such as the time period for which federal firearms licensees must maintain firearms transaction records. The AR-15 design is an example of a firearm that does not have the hammer, bolt or breech block, and firing mechanism in the same part of the firearm. Although the lower assembly is regulated as the receiver of the weapon, it houses only the hammer and the firing mechanism. The bolt is housed in the upper assembly, and therefore the hammer, bolt, and firing mechanism are not housed in the same part of the firearm. So what is the definition of frame or receiver in the final rule? The final rule includes an additional section, 27 CFR 478.12. It provides far greater detail than the current definition. The definitions of both frame and receiver are incorporated by reference into both the implementing regulations of the AECA, Part 447, and the implementing regulations of the NFA, Part 479. In addition, Section 478.12 defines that part that is the frame or receiver of a silencer, provides greater detail on when an item becomes regulated as a frame or receiver, and addresses those firearms with frames or receivers that may further be broken down into constituent parts. The final rule differentiates between frames and receivers. Frame now means that part of the handgun or variants using a handgun design that provides housing or structure for the sear or equivalent, that part that holds back the hammer, striker, bolt, or similar component prior to firing. The term receiver means the part of the rifle, shotgun, or weapon other than a handgun or variants that provides housing or structure for the bolt, breech block, or other primary components designed to block or seal the breech prior to firing. Note that the term variant is used in each definition and is therefore defined as well. This refers to weapons that utilize the same frame or receiver design regardless of the configuration of a particular weapon. So, for example, the regulated part of an AR-15 variant will remain the same whether it is configured as a rifle or as a pistol. Section 478.12A4 includes pictures of common weapons to ensure that the industry and the public have notice of those parts of the weapons that are regulated as either a frame or as a receiver. The final rule also defines partially complete, disassembled, or non-functional frames or receivers. The term includes partially complete frames or receivers that are designed to or may be readily completed, assembled, restored, or otherwise converted to function as a frame or receiver. These items include what have previously been marketed as 80% frames and receivers. The final rule makes clear that the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or other marketing materials that are sold, distributed, or possessed with the item or kit, or otherwise made available by the seller or distributor of the item or kit to the purchaser. So under the final rule, many of the products currently marketed and sold as unregulated 80% kits contain a frame or receiver that is regulated by federal law and the final rule. Section 478.12 contains specific examples intended to illustrate the concepts included in the final rule. This is one example explaining the concept from the previous slide. What has been marketed as an 80% kit will contain a receiver because a person may readily complete or assemble the frame or receiver to a functional state using the jig and instructions sold with the kit or otherwise made available by the seller. Note that not all items previously marketed as 80% firearms or 80% kits will be regulated under the final rule. Note that separate from the definitions of frame or receiver, within the definition of firearm itself, the final rule clarifies that weapons kits, sometimes referred to as buy-build shoot kits, are firearms. These are kits that are designed or may be readily completed, assembled, restored, or otherwise converted to expel a projectile by the action of explosive. This definition does not apply to those imported parts kits in which the frame or the receiver of a weapon has been properly and lawfully destroyed, for example by cutting the frame or receiver with a cutting torch and removing 1/4 inch of material in the designated area. A billet or blank of an AR-15 variant receiver, without critical interior areas having been indexed, machined, or formed, is clearly identifiable as an unfinished component part of a weapon. However, whether it is regulated as a frame or receiver depends on whether it is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. As this example makes clear, such an item that is not sold, distributed, or possessed with instructions, jigs, templates, equipments, or tools that make it readily be completed is not a receiver. Prior to the signing of the final rule on April 26, 2022, ATF had determined that some partially complete, disassembled, or non-functional items were not a frame or receiver. These were typically marketed as 80% frames or receivers. It was determined that these had not reached a stage of manufacture to be classified as such. It is vital to note that the final rule provides that these determinations are no longer authoritative, that a previous determination about the stage of manufacture of a frame or receiver is not binding. This does not mean, however, that all items considered in those classifications are now frames or receivers under the final rule. It is also important to know what has not changed under the final rule. Specifically, with the exception of items such as those partially complete frames or receivers noted above, if a part has previously been classified as a frame or receiver of a weapon prior to the final rule, it will remain the frame and receiver of such weapon. So, for example, consider the definition of receiver under the final rule, that part of a rifle that provides housing for the bolt. As shown previously, this would classify the upper assembly of the AR-15 as the receiver. However, because this determination was made well before April 26, 2022, the final rule makes clear that the receiver remains the lower assembly. This is another picture that appears in the final rule. As you can see, it clearly explains that the lower assembly of the AR-type firearms remains the receiver. It shows the receiver alone and the receiver as assembled into a complete weapon. The Ruger Mark IV and the Benelli 121 are examples of other firearms that will retain the previous frame or receiver classifications. These pictures are also included in the regulations. In addition, note that consistent with ATF Ruling 2010 TAC 3 and decades of precedent, the right side plate will remain the receiver of box-type firearms including the Browning 1919 and the M2 machine guns. This picture appears in the regulation and the right side plate is labeled as the receiver. This concludes the portion of the brief on the frame or receiver definitions.
Privately made firearms. The final rule created a new term in the regulations that implement the Gun Control Act and the Arms Export Control Act. That term is privately made firearm, and it provides the associated acronym PMF. The Gun Control Act defines the term in 27 CFR 478.11, and the Arms Export Control Act defines the term in 447.11 as having the same meaning in Part 478. So the AECA simply references the GCA definition. So what is a PMF? A PMF is a firearm including a frame or receiver completed, assembled, or otherwise produced by a person other than a licensed manufacturer and without a serial number placed by a licensed manufacturer at the time the firearm was produced. And there are exceptions that we'll cover shortly. As federal firearms licensees, you want to know what this means for you. The final rule requires all licensees to identify or mark any PMF they take into inventory. This will allow licensees to comply with GCA record-keeping requirements when accepting PMFs, and therefore it will allow ATF to trace those PMFs through licensees' records if they're involved in a crime. Now let's look at what the final rule does not do. It does not prohibit an individual from making their own PMF, nor does it mandate unlicensed persons mark their own PMF. It does not require licensees to accept unmarked PMFs into their inventory. The final rule does not apply to markings required pursuant to the NFA upon approval of an ATF Form 1. And the final rule does not apply to firearms manufactured or made before October 22, 1968, which is the effective date of the GCA, unless the firearm is remanufactured after that date. The final rule amends 478.11 pertaining to the definition of the term engaged in the business relative to a gunsmith. The term is amended in several respects, but specific to PMFs, the term is amended to include persons who engage in the business of marking PMFs. Therefore, any person intending to engage in the business of marking PMFs must be licensed as a dealer gunsmith. This amendment will allow licensees greater access to professional marking services. As stated previously, all licensees who take PMFs into inventory are required to mark each PMF with an individual serial number. The serial number is comprised of the licensee's abbreviated FFL number, which is the first 3 and last 5 digits of the FFL number, immediately followed by a hyphen or dash, and immediately followed by a unique identification number. Licensees must mark an individual serial number on a PMF no later than 7 days upon receipt or before the date of disposition, whichever is sooner. This brings us to polymer frames and receivers. ATF has long held that placing the serial number directly in the polymer does not meet marking requirements, since such serial number would be susceptible to being readily obliterated, altered, or removed. So the final rule amends 27 CFR 478.92 and explains that an acceptable method of identifying a polymer frame PMF is by placing a serial number on a metal plate that is permanently embedded into a polymer frame or receiver, or other method approved by the director. Please be aware, a licensee is not required to mark a PMF received for same-day adjustment or repair that is returned to the person from whom received. However, if the adjustment or repair is not completed on the same day and the FFL keeps the PMF overnight, the PMF must be recorded into the licensee's A&D record and must be marked with a serial number within 7 business days and before it is returned to the customer. Notably, marking serial numbers on PMFs is a customization, and the return of a repaired or customized firearm to the person from whom it was received does not require an ATF Form 4473 pursuant to 478.124. However, it requires an A&D entry. Occasionally, licensees will encounter PMFs that a non-licensee has marked with a unique identification number, or, from the non-licensee's perspective, a serial number. For example, non-licensees may be required by state law to mark their PMFs. The final rule amends 478.92 to allow for adoption of unique identification numbers. If a unique identification number marked on a PMF complies with 478.92, meaning it meets depth and size requirements, licensees may prefix such existing unique identification number with their abbreviated FFL number. Again, the first 3 and last 5 digits of the FFL number, immediately followed by a hyphen, and immediately followed by the already marked unique identification number. Please be aware, every serial number a licensee marks on a PMF must be unique and may not be duplicated on any other firearm the licensee marks. So, licensees must be mindful of serial numbers they have already used. Now let's talk about the time frame in which PMFs must be marked. As a reminder, the final rule is effective on August 24, 2022. Accordingly, PMFs in FFL's inventory on or after August 24 must be marked even if acquired before that date. Now, prior to August 24, FFLs may choose to mark PMFs themselves or contract out marking services to a gunsmith. However, PMFs acquired before August 24 that are in FFL's inventory on August 24 must be marked within 60 days of the effective date, meaning by October 23, 2022. Although licensees have until October 23 to mark PMFs acquired before the effective date, such PMFs must be properly marked before they may be transferred. For example, a licensee receives a PMF on August 1st and intends to transfer it on September 1st. The PMF must be marked before it is transferred. Keeping with the same example, if a PMF is acquired on August 1st and the licensee intends to transfer it on October 30th, the licensee must mark the PMF by October 23rd and record the serial number in their A&D records. PMFs acquired after August 24, 2022 must be marked within 7 days of receipt or before date of disposition, whichever is sooner. FFLs may contract out PMF marking services only if the person performing such marking services is doing so under the direct supervision of the requesting licensee. Let's refresh on something we feel needs repeating. Licensees must mark a PMF in accordance with 27 CFR 478.92 only if the licensee has taken the PMF into inventory. For example, a licensee handling a private party PMF transfer must record the PMF into its A&D records and mark that firearm. FFLs that do not have the capability to mark PMFs taken into inventory may have another person, licensee or non-licensee, mark those PMFs. So let's talk about persons marking PMFs for FFLs. Any person, licensee or non-licensee, who marks a PMF for the original licensee who received the PMF may only mark the PMF on the spot under the direct supervision of the original licensee recording the acquisition of the firearm, and shall mark the PMF with the original licensee's abbreviated FFL number. In addition, a licensee who marks a PMF for the original FFL who received the PMF shall not log the PMF into its records. As stated earlier, an individual who devotes time and attention and labor to placing marks of identification on privately made firearms as a regular course of trade or business with the principal objective of livelihood and profit must be licensed as a gunsmith. We need to stress, in no case may the original licensee dispose of an unmarked PMF until the firearm is properly marked and the serial number is recorded in the original licensee's records. Now let's talk about PMF record keeping, and we'll begin with A&D records. To reiterate, except for a PMF received for same-day adjustment or repair and returned to the person from whom received, licensees must record the acquisition of a PMF by the close of the next business day following receipt of the firearm. Regarding the A&D serial number, if the PMF received is not already marked with the serial number by a licensee pursuant to the final rule, licensees shall leave the serial number portion of the A&D record blank until the PMF is properly marked. However, licensees must mark PMFs within 7 days of receipt or prior to disposition, whichever comes first, and if marked before the 7th day, licensees must update the A&D record once the PMF is marked. Regarding the firearm description in the A&D record, the final rule also amends record keep regulations to allow licensees to record privately made firearm or the acronym PMF in the description of firearm section. This was formerly the licensed manufacturer and/or licensed importer name. Lastly, as with A&D record keeping, the final rule amends 27 CFR 478.124 to allow licensees to record privately made firearm or the acronym PMF on the ATF Form 4473 as the name of the manufacturer.
Marking requirements. It is probably not surprising that marking requirements under the final rule are intended to increase the success rate in tracing of firearms used in criminal activities. All are likely aware that licensed manufacturers and importers are required to place the serial number on the frame or receiver of a firearm. Obviously, additional markings are required under the implementing regulations, section 478.92, and include the model, caliber or gauge, and the name, city, and state of the manufacturer or importer. These markings may be placed on the frame or receiver, the barrel, or on the pistol slide as applicable. Under the final rule, licensed manufacturers and importers are required to identify each firearm by placing the serial number, name of the licensee, and the city and state of their place of business on the frame or receiver in accordance with the regulations. These markings may no longer be placed on the barrel or pistol slide if applicable. Please note that there is a vital caveat to this, however, and this will be addressed in detail in a moment. The final rule provides two options for marking the serial number, name, and place of business on the frame or receiver. Specifically, a frame or receiver must have an individual serial number and one of the following: either the name of the FFL and the city and state in which the FFL maintains its business, or the name of the FFL and the abbreviated FFL number, that is, the first 3 and last 5 digits with no dashes as a serial number prefix, followed by a hyphen, then the assigned unique identification number. The final rule also includes marking requirements for multi-piece frames or receivers. Multi-piece frames or receivers means a frame or receiver that may be disassembled into multiple modular subparts, including standardized units that may be replaced or exchanged. We will consider this further in just a moment, but this term refers to a frame or to a receiver that itself may be broken down into, for example, front or back sections or left and right sections. For a multi-piece frame or receiver that has more than one outermost component, all similar parts that are required to be marked must be marked with the same serial number if sold together as a complete modular frame or receiver. However, the final rule requires each outermost modular subpart of a frame or receiver be marked with a unique serial number when the modular subparts are disposed of separately. The outermost housing or structure that meets the definition of frame or receiver is the subpart of a multi-piece frame or receiver that must be marked with the identifying information. If more than one modular subpart is similarly designed to house, hold, or contain such primary component, for example, the left and right halves, each of these subparts must be identified with the same serial number, not duplicated on any other frame or receiver. This is an example of a multi-piece receiver. The top picture is a typical one-piece AR receiver looking down into the fire control area and the magazine well. The bottom picture is an example of the same item as a modular receiver in which it is split in half, having a left and right side. Note that both halves provide housing for the fire control components, and therefore each must be marked pursuant to the final rule. Once modular subparts of such a receiver have been marked and aggregated, the final rule makes clear that parts cannot be removed and replaced because doing so would violate Section 922K of the Gun Control Act, as well as provisions of the National Firearms Act, if applicable. A marked part may be replaced if certain conditions are met. First, the replacement part may not be a firearm as defined by the NFA. Second, the original manufacturer must serialize and replace the part as prescribed. And third, the replaced part must be destroyed by that licensee or under that licensee's direct supervision. The final rule also defines which part of a firearm silencer or muffler is properly classified as the frame or receiver. In the case of a firearm silencer or muffler, the regulated part is the outer tube or modular piece that provides housing for the primary internal components. Regarding firearm silencers, this generally refers to the expansion chamber that may house the baffles or baffling material. Modular silencers are those that are designed to utilize more than one such part. However, the final rule requires that in such designs, the frame or receiver is that part that attaches to the weapon that expels a projectile. That is, for example, the part that attaches to the pistol or the rifle. The final rule makes clear that the removable end cap is not the frame or receiver of a firearm silencer. This is an example of what is sometimes referred to as a modular silencer. The top picture is a complete silencer assembled with each of the components. The bottom picture is that same device broken into constituent parts. As is clear, that portion that attaches to the weapon is the part that must be marked pursuant to the final rule. If more than one part attaches to the weapon, each part must be marked pursuant to the requirements in the final rule. The final rule also formalizes a long-standing practice. That is, minor components of silencers need not be engraved or registered when transferred between special occupational taxpayers for certain purposes. This includes, for example, components such as the K-baffles shown here. However, a part of a firearm silencer that is transferred to an individual remains subject to all of the provisions of the Gun Control Act and the National Firearms Act, including all marking, registration, and transfer requirements. Under the final rule, there will be few circumstances in which there is more than one serial number placed on a firearm. As will be discussed, under certain circumstances, licensees are permitted to adopt markings placed on a firearm by another licensee. Further, the final rule amends the regulatory definition of transfer in Part 479 to make clear that the temporary conveyances of NFA firearms are not transfers. This is based on the statutory definition of transfer in the National Firearms Act that defines this term in part as a disposition of the firearm. For example, an individual who temporarily conveys a firearm for repair has not disposed of that item and therefore has not transferred it under the NFA. The final rule also formalizes the time limits to mark firearms. GCA firearms must be marked within 7 days after completion of the manufacturing process or prior to disposition. NFA firearms must be marked by the end of the next business day after completion of the manufacturing process or prior to disposition. This is based on the time limit to register an NFA firearm using an ATF Form 2. Licensees are permitted to adopt and are not required to mark the serial number or other identifying markings previously placed on a firearm under the following conditions. First, licensees may adopt the markings on newly manufactured firearms that have not been sold, shipped, or otherwise disposed of to a person other than a licensee if the serial number is not duplicated. Second, a licensee may adopt the serial number when a licensee remanufactures or imports a firearm that was sold, shipped, or disposed of to a non-licensee when that licensee identifies the firearm with their name, city and state, or their name, the letters FFL, and the abbreviated Federal Firearms License Number. Third, a licensed manufacturer may adopt markings if performing services as a gunsmith on an existing firearm that is for a non-licensee and is not for sale or distribution. The final rule allows manufacturers and importers to mark firearms other than PMFs of the same design in the same manner as before the effective date of the final rule. Except those items marketed as 80% receivers, firearms that ATF classifies prior to issuance of the final rule are grandfathered and may continue to be marked in the same manner as before the effective date of the final rule.
Record-keeping requirements for manufacturers, importers, and dealers of GCA firearms and manufacturers of NFA firearms. The final rule requires all importers and manufacturers to consolidate their records, which means they can no longer maintain a separate disposition record for the activity conducted. Prior to the final rule, the regulations required that manufacturers maintain separate sets of records for the activity conducted, meaning one set for firearms manufactured, including quantity, a separate set for firearms transferred to other licensees, and another set for firearms transferred to non-licensees. Requirements were the same for importers. There are ATF rulings in place that allow for manufacturers and importers to consolidate the activity described into a single record instead of multiple sets. Amended regulations in the final rule will require the consolidation of records, and there will no longer be an option to retain multiple sets. For clarity, the new rule does not require consolidation of records between FFLs, and in no case should a company that holds both manufacturers' licenses and importers' licenses to combine or consolidate their records together. This will not be a change for the overwhelming majority of manufacturers and importers, because the consolidation of acquisition records, whether manufacturer, importer, or otherwise, with the disposition records is a common industry practice for all licensees. New regulations require all licensees eliminate duplicate entries. What does this mean? If a licensee records a duplicate entry, whether to close out an old record book or for any other reason, the licensee will need to record the date and location of the subsequent entry as the disposition. What will this look like? The closeout entry may show, for example, the date of entry, book name or book number, page number, and line number as the disposition. The entry being closed out must clearly reference the entry that remains open. The final rule clarifies that dealers, manufacturers, and importers may conduct same-day adjustments or repairs without recording the firearm into the A&D record, as long as that firearm is being returned to the person from whom it was received. Manufacturers are required to record the acquisition of GCA firearms manufactured or otherwise acquired within 7 days or prior to disposition, whichever comes first. Whenever there is more than one manufacturer or importer, country of manufacturer, or serial number marked on a firearm, the licensee is required to record all of the markings in the A&D record. Any FFL number marked on a firearm as part of the serial number must be recorded in the serial number column of the A&D record. For tracing purposes, each serial number must be separated by a semicolon in cases where more than one serial number is present. With the exception of same-day adjustments or repairs returned to the same person, All firearms acquired by an FFL must be recorded as an acquisition. Manufacturers must record NFA firearms in the A&D records by the close of the next business day, unless the manufacturer has commercial records of acquisition, which extends the entry requirement until the 7th day. Manufacturers may delay the submission of an ATF Form 2, Notice of Firearms Manufactured or Imported, if Number 1, silencer parts are transferred between qualified licensees for further manufacture, or 2, to complete silencer devices that will be registered upon completion, or number 3, to repair existing registered devices. In cases where the FFL SOT manufacturer has transferred silencer parts to another qualified FFL SOT manufacturer for further manufacture, i.e. machining, coating, etc., or manufacturing a complete muffler or silencer device, the manufacturer who completes the device would be responsible for identifying, recording, and registering it. FFL SOT manufacturers may transfer a replacement part defined as a silencer other than a frame or receiver to another FFL SOT licensee without identifying or registering such part, if the purposes are for repair and it has been previously registered in accordance with the regulations. The final rule requires all licensees to retain all required records until the license is discontinued. A&D records must be kept on paper or an approved electronic format at the licensee business premises and accessible for inspection. A warehouse may be used to store paper records older than 20 years of age. That warehouse would be subject to inspection and cannot be used to conduct other firearms business activity without obtaining a separate license. Licensees can no longer send their records older than 20 years to the Out of Business Records Center, National Tracing Center. They can only submit their records upon discontinuance of the license.
Rulings and procedure affected. As you are aware, ATF publishes formal rulings and procedures to promote uniform understanding and compliance with federal laws and regulations. Many of the following 15 rulings and one procedure have already been touched on or reviewed. This section will summarize and elaborate on them. Ruling superseded. The term superseded is used to describe a situation where the position set forth in a prior ruling is displaced and rendered ineffective by the rule, which may incorporate the prior position or provide a substitute position. The following rulings have been superseded by the new rule. ATF Ruling 2009-1, Firearms Manufacturing Activities, Camouflaging or Engraving Firearms. Previously, camouflaging and engraving was allowed under a dealer's license regardless of the purpose. The new rule establishes that if the activity performed is for the purpose of distribution or sale, the manufacturer license is required. ATF Ruling 2010-10, Manufacturer's operations may be performed by licensed gunsmiths under certain conditions. This ruling allowed for manufacturers' activities to be performed by gunsmiths under certain conditions. Again, under the new rule, if the purpose of this work is for sale or distribution, the manufacturer's license is required. ATF Ruling 2009-5, Firearms Manufacturing Activities, Identification Markings on Firearms. Non-marking variance requests are no longer required under certain circumstances. The final rule provides 3 exceptions for when and how a licensee may adopt existing markings. First, when a firearm has not been transferred to an unlicensed person. Generally, these are newly manufactured firearms. Under this circumstance, the licensee may adopt the required markings. Second, when a licensee remanufactures or imports a firearm to an unlicensed person. Lastly, when a manufacturer performs a gunsmithing service for an unlicensed person on their firearm which is not for sale or distribution. ATF Ruling 2012-1, Time period for marking firearms manufactured. Now, all GCA firearms must be marked within 7 days after the manufacturing process is complete or prior to disposition, whichever comes first. ATF Ruling 2013-3, Adopting Identification of Firearms. This ruling allows for licensees to adopt all markings, but have to indicate their name, city, and state. Under the new rule, You may adopt the markings provided the manufacturer or importer places the name of the FFL and abbreviated FFL number on the firearm, not as a prefix to the serial number, or, as before, putting the FFL's name, city, and state on the firearm. ATF Rulings 2011-1 and 2016-3 are now superseded as all records now must be combined under the new rule. If a business has both a manufacturer and an importer license, each manufacturer and importer license must keep distinct combined records. Do not combine the manufacturer and importer licenses records. Rulings amplified. The term amplified is used to describe a situation where no change is being made in a prior published position, but the prior position is being extended to apply to a variation of the fact situation set forth in the rule. Thus, if an earlier ruling held that a principle applied to A and the rule holds that the same principle also applies to B, the earlier ruling is amplified. The following rulings have been amplified. ATF Ruling 2002-6, Identification of Firearms, Armor-Piercing Ammunition, and Large-Capacity Ammunition Feeding Devices. The new rule amplifies the terms conspicuously and legibly to explain how they apply to marking of frames or receivers, including the multi-piece frames and receivers and modular silencer devices. The ruling still applies in all other respects. ATF Ruling 2016-1, Requirements to keep firearms records electronically, and ATF Ruling 2016-2, Electronic ATF Form 4473. These rulings are amplified as the new rule requires all records be retained for the life of the FFL. Records older than 20 years cannot be destroyed. Rulings clarified. The term clarified is used to describe a situation where the language in a prior ruling is being made clear because the language has caused, or may cause, some confusion. It is not used where a position in a prior ruling is being changed. The following rulings have been clarified. Revenue Ruling 55-342. FFLs assembling firearms from component parts. Now, gunsmiths must be licensed as a manufacturer if the activity conducted on the firearm is for the purpose of sale or distribution. ATF Ruling 77-1. Gunsmithing at shooting events. The original ruling only identified licensed dealers as being able to perform these activities. The final rule makes it clear that licensed manufacturers and importers may conduct same-day adjustments and repairs to firearms and return the firearm to the person from whom they received it from without recording a record of acquisition and disposition. ATF Ruling 2009-2, Installation of drop-in replacement parts. This ruling stated that gunsmiths who engage in the business of installing drop-in replacement parts must be licensed as dealers. This ruling is clarified in that licensed dealers or gunsmiths may install drop-in replacement parts to repair their own firearms or to repair guns for other licensees who plan to sell them. ATF Ruling 2010-3, Identification of Maxim side plate receivers. As shown earlier, the final rule clarifies that Vickers Maxim receivers may continue to be marked on the right side plates unless the receiver has been altered. ATF Ruling 2015-1, Manufacturing and Gunsmithing. The new rule defines gunsmith and clarifies when the manufacturer's license is required. Dealers or gunsmiths must be licensed as manufacturers whenever they perform work that produces or remanufactures firearms to include frames or receivers for sale or distribution. Procedure clarified. ATF Procedure 2020-1, Record-keeping procedures for non-over-the-counter firearm sales by licensees, the unlicensed in-state residents that are NICS exempt. The ATF Form 4473, May 2020 version requires that the firearm description, items 1 through 6 on the ATF Form 4473, must be completed by the FFL prior to sending the form to the customer. This procedure must still be followed whenever non-over-the-counter transactions are conducted in accordance with Section 478.96b. The following links provide resources which you may find beneficial. Of note, the e-regulations website has all the federal firearms regulations as they currently exist and will be updated when the final rule takes effect in August of 2022. Regulations may be printed as you need them. For inquiries regarding the topics reviewed in this training, email the ATF Firearms Industry Programs branch at the email address shown here. The subject line should state frame or receiver final rule. For any firearm technical questions you may have, please contact the Firearms and Ammunition Technology Division. And for any inquiries regarding the rulemaking process, please contact us at the Office of Regulatory Affairs.